the discussion. And let me tell you, they have permission to correct me if anything, because these are the pioneers in the field, and I've learned a lot from all of them. I already introduced Jack Cooley, but as a reminder, he used to be a federal magistrate. He's been mediating and arbitrating for over 20 years, and has taught at numerous universities and has a wide breadth of experience in the mediation and arbitration field. Moderating today and part of the discussion today, Lynn Cohn. She's a professor at Northwestern University Law School, teaches numerous courses in negotiation and I think in alternative dispute resolution. And she's a longtime mediator and arbitrator, and in real interesting cases. I know a certain period of time we were doing Delcon Shield arbitrations. And she's on our board of directors and has been a volunteer and trainer for us for a long time. And then Mr. Bill Hartgering. I think I referred to a mediator I co-mediated with earlier this morning, where that mediator told me to watch my facial expressions and not get too down because the parties can see that. This is Mr. Hartgering,
Coach Hartgering,
right? Who he opened the Jams and Dispute office in Chicago in 1981 to 82, and he was doing mediation here in the civil litigation context during all the lean, struggling years when no one in the world knew what mediation was, and now has an incredibly successful national practice from huge construction cases, employment matters, and you name it. So
I think the more important thing is that I first received training here. I learned all about mediation here in October of 1981, and that was my introduction to the field. And I really do still remember what I learned from it and the mediations I did here back in those days.
Good segue, so I'm going to let you guys start talking.
Well, I'm going to tell you that I'm going to share a secret. I agreed to do this today, not because I wanted to tell you what I knew, but I wanted to hear what they knew. I think it's wonderful to have an opportunity to sit down with people. We probably have different practices, but a lot of similarities, a lot of differences, and to have a chance to talk about our craft, to share our ideas with you, to get your input, and to brainstorm here a little bit. And where I wanted to start today, I wanted to talk a little bit about what we like about mediation, what we don't like about mediation, since we do this quite a few hours a week. So my first question would be, what do you like about being a mediator?
Well, what I like about it is the satisfaction that you have if you get a resolution, and even if you don't get a resolution, I think there's still satisfaction in helping people to get to a certain point in their dispute, or to realize that they cannot resolve this thing at this time. There might be a later time. As a matter of fact, it happens often, and I think that I would get some agreement here, that even though in the mediation conference itself, you might not be successful on a particular day, you'll find out through subsequent telephone calls that you can bring people together even over the telephone. For me, the satisfaction of the job is very high on my list.
I think what I'm struck by is that it is an opportunity to be enormously creative. On a case-by-case basis, there's a basic format that I have, and I'm sure Jack can do the same thing, but I'm able, particularly as I meet with the parties beforehand, to try to figure out, all right, what's going to make sense here? What do I need to do with the individuals at the table? What is going to be more effective with them? And that the more I can understand about what's driving those individuals and what I can do to be most effective with them, makes this, every case is different. And every case really is an opportunity to do that kind of work, and the impact that I think I can see that I have when the case resolves, or even when they've gotten close together, or it's the first time they've ever been able to be in the same room with each other and be civil, is enormously satisfying. Most of the cases, parties start out enormously distrustful, not liking each other. A lot of the cases that I have, they have a history that goes back years, if not decades, and they've spent an awful lot of money. They got a whole lot of reasons that they don't trust each other. When we get the matter resolved, and the vast majority of them are, it's amazing to see the shift in the energy that people are. I mean, we have, when we sign the agreement, everybody wants to be in the same room They are treating each other vastly differently, and the change that really the process brings about is really remarkable. I mean, when I was a lawyer, people talked about the best settlement's the one that neither side is happy. And that there's a certain amount, I mean, that's the conventional wisdom, and there is something to that. But as a litigator, that's sort of what I did, is I got settlements that neither side was happy because we'd settle on the courthouse, people wouldn't have a day in court. But this, they walk out in most of the cases. Sure, there are lots of cases that, you know, they're just talking about dollars, two insurance companies, and they walk away with that. But many, many more of the cases, there's another element beyond each side is happy. They've had something that they needed to happen, and they can walk away in a really different stance.
Do you find that in your cases that at the end of it, people feel happy and it's not, well, I gave too much, or, okay, I agreed and I got rid of it? Do you find that in your cases? You do? Does anyone not feel that way all the time?
Sometimes we see relief. I don't know that it's always happiness, but they're very
Right.
happy to have got, well, happy, there's the word, to have gotten past that juncture and
I think relief's a great word.
Yeah, it's better.
moving on. Well, but
Yeah.
of course, relief does generate happiness to us too.
Maybe not at that moment.
Right, in the long haul.
They're so happy that it's over.
Yeah.
Right, it's
Well,
also relief in that they didn't know what it was going to be about. They didn't know how it was to work.
Right.
And once they got there and found out it perhaps was not as bad as they had imagined, they're able to get beyond their initial fear.
It certainly is true for
And go
people who
home.
are sitting down in a mediation, don't know what it's all about.
Mhm.
Even though they've been told in advance,
Exactly.
don't know exactly what you're going to be doing there to them. I wouldn't even say for them, I would say to them.
That's what they're worried about.
Right, right. It's very hard. It's very difficult.
I recently saw this release occur. I'd never seen it happen like this before. It happens in the smaller cases and it happens in the very large cases. This was a mediation, it was a class action, and on the other side were several government agencies. So we'd spent about 2 days in mediation already. For a lot of things, obviously, we worked out, but the first one was the money. And they couldn't work it out because at issue was about $150 million. And we worked and worked and worked. And we worked to this point where we couldn't get anything together, and then I let them design the process. I won't go into it right now. It's what we're going to do then to break this deadlock. And it was, once they broke the deadlock, I've never seen anything like it. I mean, it was like people were shaking hands on both sides of the aisle and then across the aisle, hugging each other. But they had a lot more to go. That was just the monetary issue. These other issues. So I sat around for about 2 hours that afternoon, you know, to help facilitate it. And after about 2 hours, they said to me, "Sorry, Jack, we don't really need you anymore." And they were doing so well, they just negotiated everything else. So you're going to find out that barrier sometimes hard to get over in smaller cases, but in the larger cases, the same thing.
And that's fine. Sort of the theory of mediation is that eventually maybe people won't need us anymore. I'm not holding my breath. But the idea that they're able then to take over, I mean, that's just fine, isn't it?
Yes.
Yeah.
I think that your statement on the change that the process brings about is really a very important one. But what I've been seeing is that people do have that euphoria when they make they hit their aha point, and then they're able to renegotiate. But then they go away and they move away from that. And you're no longer part of that negotiating process. Some things fall apart in their feelings, or not necessarily in their payments or anything, but what have you noticed, or are there other techniques that you use in order for that not to happen? I mean, I just think of even big negotiations, thinking of the Middle East or Northern Ireland or something
Sure.
like that. There's something that happens after that euphoria that stops something.
If there's going to be an ongoing relationship, one of the things you might think about specifically adding to the agreement is, you know, while that euphoria is there, how do we structure our what have we learned from what we've done in the past, and how do we put in our agreement a mechanism for dealing with each other? And so think through that aha might be lost, and to try to provide some structure for that. Also, as a basic, I don't, at the end of all of my mediations, I always do a first draft of a mediation agreement. I can carry a computer with me, and I type it out, and a boilerplate on that is a dispute clause, is a mediation clause or an arbitration arbitration clause. So that's also setting up a mechanism that if they have a difficulty, they can come back. My experience is very few of them have had to come back, and I think the mere fact of that clause being there, they're going to work a little harder to try to get it done. But some of that aha might be lost, and if you know that they're going to have to work on with each other, in most of our cases, that's the last time they're going to see each other, but if it's an ongoing relationship, add that to the negotiation. And at some point you might get some struggle with that because people say, we had enough trouble getting this done. But push them a little harder to say, well, you're all going to have this problem again. What can we do now that we're in this good situation that we can set up so that, short of having to bring in a neutral again, which nobody wants to do, short of that, or maybe in addition to that, that we can talk about how the parties are going to work better with each other and get some discussion with that and get some points of your agreement.
Marion, are you in a situation where after mediation you see people the next week or the next? See, we usually, just so you know, we usually would not unless something came up. After the mediation session, I don't get to see a party. Sure, we hope to see the lawyers again soon. But you might not see the party who's probably going to be the person who's going to say, gee, do I have a little buyer's remorse here? How am I feeling about this? Are you in a situation where that happens?
Well, I think that when you're not, we've been talking a lot about money negotiations, but there are also personnel negotiations and other ways that you try to solve the problems that are there that are done from a human resource position. And then sometimes when people go back, they're not always comfortable with maybe the decision they made, even though they know that it was good when they did it, but what are some of the changes and, all kinds of, do they feel like they were manipulated? I mean, there are all kinds of human conditions that come into play at that particular point.
One suggestion I would have for you, if that's something you find based on your situation and being there with people and seeing them 2 weeks later, would be to talk about that. To maybe in a caucus situation to talk about it. This is how you're feeling now. Let's talk about how you think you're going to be feeling in a couple of weeks. I mean, sort of build into there, it's possible, where are you at on this right now? Or if you could you build in a follow-up for people? If it's on the job, that's a possibility. The beauty of mediation is we can change the process. We can build things in if we think it's necessary. If you're finding that pattern that after these great sessions, people are having remorse about what they had done, we might need to change that process for you in order to let it work.
I've heard some people express that if the field of mediation were regulated, that it should be limited to people with law degrees or mental health degrees. I'd like to get your...
I hope this camera's picking up the expression.
How do you feel about that, and is the field open enough for people who do neighborhood mediations and what have you?
I'm going to respond to that because I feel so strongly about that, and I will tell you that I find there was a period of time when I was doing both litigating and pro bono mediations here at the Center for Conflict Resolution, and I found that I actually had to unlearn a lot of lawyerly conduct in order to be effective as a mediator, and I had to give myself at least an hour between the end of my day as a lawyer and the start of my night as a mediator in order to be effective. So I don't think that being a lawyer gives you particular skills that are going to necessarily make you a better mediator than anyone else. And we're here to tell you that some of us are able to overcome some of that and to move into a different direction in mediation. But there are basic skills that you need to have as a mediator that you can get from lots of different walks of life. There's no doubt about it. The piece that's going to be difficult, and I will share this with you because I have friends who have been trying to break into the field without being lawyers. If you want to have a practice where you hang out your shingle and you mediate, unless you're in an area where, say, a therapist and family mediation does real well, it will be difficult for you to market because lawyers who are in our process feel more comfortable, I think, with lawyers, with someone like them who understands their perspective and their experience. So I think that there are two areas. Marketing is helpful, and perhaps to be able to talk through with the parties what litigation might be like for them. A little bit the concept of reality testing and asking questions and talking with them. Sometimes it can be helpful when somebody mentions that they're before Judge X to say, Judge X for 3 years hasn't ruled in favor of a plaintiff on a summary judgment motion. I mean, to be able to talk a little bit about that can be helpful, just based on that experience. Not necessary at all. I don't think being a lawyer is a prerequisite to it, and I think that there are a lot of things that lawyers do that they have to unlearn in order to be effective.
I would agree, and I have to, I guess, keep reminding myself that when I'm a mediator, I am not practicing law. I'm really not a lawyer in practicing law anyway. I think there are so many opportunities for non-lawyers to do a lot of good for society, for community, by being mediators. And I'm so happy to say that I'm seeing a lot of people, such as yourselves, moving into this field. There's always going to be, I believe, enough cases around for lawyers to mediate. And I think that's going to be very true. I think there are going to be certain aspects of non-lawyering fields that might be used more readily, maybe in the mental health area, or maybe in the therapeutic area that will come into to do mediation. But I really support the whole idea of non-lawyer mediators. I think
the other area you'll see it is in the ministry, that there are other occupations that are just, it is appropriate that those are skills that people in that profession have to develop. And because of that, I'm not sure how much outside practice ministers are allowed to have, but there are some natural areas where there are going to be market niches. The Society of Professional Dispute Resolution, SPIDER, has been very aggressive. I was on both certification commissions. That anything that has come out of that has always said this can't be limited to just lawyers or just any one profession. So there is some assistance there. All that being said, the reality now, if you were to look at 50 people in Chicago or 15 people in Chicago that were making a living at them, I think the top, and you were looking at any kind of volume there, the simple reality is that if you probably have to go down below 50 of the top 50 just on income, probably all 50 would have legal background. Dave Ferguson is somebody that for a long time was an example. He was one of the first graduates of George Mason's program on conflict resolution. He was a non-lawyer. He was with us for a period of time. I think it was very good. But he was really the exception. So the marketing reality is stark. And that it's so stark that I say to people, if you really want to do this, you might think of whether you want to go to law school. Don't go to law school if you don't want to go to law school, but if you really want to make a living at it, that may be a useful credential. I think the training you get, I find helpful. I would agree that I have to unlearn it, but I don't think I would be as effective in the cases that I'm in, and I wouldn't have the practice that I have if I hadn't been a litigator for a chunk of time. So it should never be narrowed, but the reality is that there are advantages to the way the market is now. The way the market will be now 15 years from now, I'm hoping it's going to be broader, because I'm hoping that it will become a part of mainstream, that at a whole lot of levels and a whole lot of areas, people will turn to mediation. And in most of those areas, a legal background is not at all necessary, and the gatekeepers who are choosing the people won't be lawyers. But for right now, the gatekeepers are largely lawyers in the 4 feet aspect.
What I'm worried about is that some regulatory bodies around the country, attorney regulatory bodies, are going to make mediation basically the practice of law, or try to. I think that would be the wrong way to go. I quite frankly, now, when I mediate, it's very uncomfortable to me as a lawyer to perform mediation services for parties who are not represented. I think that there is always going to be those opportunities for non-lawyers mediating cases in which parties are not represented, because what happens is those parties look to me to get, even though I tell them I can't give any legal advice, they still look to me for some kind of advice, either as to process, procedure, what is this case worth, and things like that, which takes into account sometimes, what the lawyer's thinking, and for a lawyer, it's very hard to separate that out sometimes. So I think that those particular situations, unrepresented parties, is a really good situation for non-lawyer mediators.
Are any of y'all lawyers? No? And are any of you trying to break into the field? So we're discouraging people here. So what we need to, yes?
Oh, go ahead. I have a question about this.
Okay, you go ahead and I'll move to the next topic in a second.
I may have misunderstood this somewhere along the line, but my understanding was that there was some legislation that was proposed in the state of Illinois regarding having mediators be lawyers, that had to go hand in hand. Do you know where that stands right now in terms of legislation? I was told that it may be as much as 10 years away, but it could be as close as a year away from that coming into law.
Is that something that you're expecting?
I have not heard of that.
Yeah, I have heard of that. There have been bills floated that have said that in the divorce area. Cookie would probably know more about that, but the fact, I mean, there's a lot of times there's an unnecessary scare. I mean, you can drop a bill that says about anything you want, and there have been some very strange pieces of legislation that have been floated. I'm not aware right now. Florida for a while had lawyers only, and they changed it. And there were some other states that they sort of started to go down that road, and people like Spider, and I think Spider took a very active role with that and sent people down to the legislature and said, don't do it this way. And I think there aren't any, maybe the divorce folks did that too. So that, I mean, that may be less of a concern now than it was a little while ago. It's something that needs to be watched out for, because certainly it's something that if you talk to lawyers groups, they certainly have a self-interest in that, and so it certainly could happen.
Do you know what Spider is? Let me just be sure. Okay,
I'm
he
sorry.
keeps referring to Spider.
It's acronym.
It's
The
a-
Society of Professionals in Dispute Resolution. It's the only broad-based trade association that the profession has. There are also very good associations that deal with labor. Actually, there's two, or that deal with people that practice primarily in the divorce area. But it is the only sort of group professional force dealing with the ABA and dealing with other American Bar Association and other trade associations in this area.
There is
Professional associations, I should say.
I think there's a set of rules under consideration, have been under consideration by the Supreme Court of Illinois for a long time in mediation court cases. And I think probably in that system, lawyers would be
Yes.
the mediators. Maybe that's something that and that this has happened in other states where courts will only allow mediators or lawyers to be appointed in these court system kinds of programs. But another thing is, I believe, and I hope the bar associations are moving this way, that problem solving and mediation is getting more multidisciplinary. And I see down the road that we're going to have co-mediations that would involve maybe a lawyer and some other kind of professional person in mediation. We already see it in certain kinds of divorce situations where CPAs are needed in other kinds of cases. But I see maybe three or four people co-mediating a case. So I'm not too worried about the whole practice of mediation, of going into the legal, or being a lawyer being required to do it.
Just to take this one step further, I can see the relevancy of knowing certain aspects of the law and not being a lawyer. So why wouldn't some group such as CC or Spider himself promote a course that would be a background for the kind of legal issues you need to be familiar with as a mediator and do it that way?
Yeah. There is actually a course coming up in December that Spider is putting on employment law, some of the statutory and regulatory issues related to that, and then it will segue into applying that to a mediation practice. But I don't think that's been something that you've seen in every area as an area of training that's prevalent, and it's an idea that, are you taking notes over there?
Absolutely.
Because it could be a very good idea to do that, but I'm seeing that starting to happen more and more. And there is one in December that Spider's
Part of
putting on.
the CCR training, even 10 years ago, had a segment on, basic principles in landlord-tenant law. And so I think that's done now in most training. If you know it's going to go into a certain area, that those legal principles are provided. I think other trainings, particularly when they know that people are going to use it in an area, that's exactly right.
What I think that we could do now would be to give you some tips for breaking into the mediation field that don't involve going to law school, moving off of that topic, and thinking about other ideas for people. And I know some of you, this isn't an issue, but I think for some, I think you raised your hand. So let's share some thoughts about that. Bill, when you broke into this field, it was probably very tough.
Well, there was just, people
What
didn't know what
field?
it was, right?
What field?
That's meditation, right? Meditation, there's only one vowel that's different. And so, beginning piece was doing a lot of essentially training. not training in the exact text, but in going to all the law firms and sort of explaining what this was and what it wasn't. Because back then, people didn't know about law schools. There weren't people teaching what Lynn is now teaching. I had the pleasure of teaching her similar courses there, but that was in the middle 80s, and it wasn't being done much there either. I think the other really important thing is at some point, perseverance is very important. You've got to spend a lot of time talking about this. You have to enjoy talking about it. I ate a lot of rubber chicken and Rotary groups. I went to, all the traditional things that somebody might go to talk about it, thinking that at some point, if somebody had a case, that something might happen with it. As of that time, since people didn't know what it was, and it wasn't something that lawyers were using, that wasn't very successful then, but I think it would be now. You read about mediation all the time now. I mean, it's much more a part of people's understanding, and I think people have a better idea of what the options are. So those kind of going to various groups where there are small businesses, chambers of commerce, and things like that. I think the other thing that is important is your resume has to have something more than just, what kind of degrees you have. And it needs to talk about specific experience in cases, and to a certain extent there's a catch-22 there. You got to get the experience to write about it. But even cases that you do through something like the center here, or in a variety of other cases, there is information there that you can talk about after you talk about your, the background that you have. And this is some of the specific experience that I have. And that it's very important that to the extent people have been involved in those mediations that are happy with it, that you can use them as references. This is very much of a word-of-mouth issue, and people want to know both, and that's why it's happened easier with lawyers. Well, tell me some of the lawyers you've worked with, or creating pieces of paper that has the names of various people that you've worked with, and somebody can say, aha, I know that person. I know them separately. I can get a good information from them. So you have to keep records of all the stuff that you've done, describe it in a way that is generic, so you're not obviously affecting confidentiality, but that you can say to somebody, I've done this before, and these are the kind of cases that I've done it, and that when you're responding, right now, a lot of times when I'm chosen, they're chosen among a variety of other people as well, both within my company and outside of my company, and that they have to try to figure out, why should I choose A over B? And so the more information you have with that, the time that you spend to develop that material, and if it's tailored to the particular dispute that they're thinking about, so you're going to have to get creative with your word processor and do quick cut and pasting, that's also very, very helpful. The kind of paper that people create right now that people send out isn't very good generally. Mediators aren't very good at marketing themselves generally. And that thus you have an opportunity there. But it's going to take some time to develop that, to ask people if you can use them as a reference, to ask parties if they mind whether you describe, their case, and you might want to send them a little blurb. It creates a lot of extra work, but you're building something there to pass on to somebody when they're trying to choose you as opposed to someone else.
Yeah, I just say, don't give up your day job. I have to tell you that my suggestion is to get active in organizations. After you get the basics, which I believe you folks already have, that is, you've done some reading, you've been trained, I would suggest even getting more training. Find out which type of dispute situation that you like the best to be involved in. Let people know that you do mediate. I mean, you might have other organizations that you're involved in, even the church. If you go to a church regularly, let people know that you do this. I think it's really important. I also think that what Bill said is very important. Start building your resume, essentially. When you go to a training, make sure you keep a record of that, put that on your, most of you can do word processing, just come home and put it right on your resume that you've been through this, and you'll see this thing grow. It's unbelievable. One thing about this field is, I believe, is that from an income stream point of view, it's very unpredictable, certainly starting out. Bill and I think, started out in the field about the same time in the private sector. I was, at that time, in a law firm, coming out of a law firm, trying to basically straddle for a while, doing some legal work, you know, traditional type, and doing this. But it takes time to build a practice. Even now, maybe I shouldn't say this on video.